And we begin this hour in the KwaZulu-Natal. The Durban Magistrate Court is today finally expected to deliver judgment in the bail application of 5 men arrested for the killing of South African rapper Kiernan aka Forbes and his friend Tebello Motsoane. The 2 men were shot dead outside a popular restaurant in Durban last year. Vusi Khumalo is part of our team watching developments and joins us now not too far from the court precinct itself. And Vusi, we had heard, quite frankly, weeks of a back and forth between the defense and the state around why these 5 men should or shouldn't be granted bail. In some instances, the state arguing that the men should be kept inside the prison cells because they're dangerous to society.
Yes, of course, Ayanda, uneasiness lies the head that wears the crown in this case. It is the magistrate, Vincent Hlajwayo, who will have to determine as to whether the 5 are given bail. Of course, this matter will be judged on its own merit according to the affidavits that have been deposed before this court. We know that both parties, especially the counsel for the state and the counsel for the defense, have presented their strong cases so far, with the state saying that the 5 must not get bail because they might even evade trial, and also they've been very dishonest, that's according to the state, in also with the defense saying that they've proven themselves to be good people, even though some of them were arrested in various provinces, including Gauteng, as well as here in the province of KwaZulu-Natal. We also know that the other case that is currently taking place in Eswatini, the extradition that is taking place there, the country of South Africa has also written or requested that the 2 must be extradited back to South Africa so that the festive music here in the country of South Africa. So that case is currently underway in Eswatini. But to bring us more details on this, what is currently happening here in court, perhaps let us start where we should with regards to the case that is currently taking place in Eswatini. How difficult is it for this one here taking place in South Africa for the 2 matters, because they are currently underway? How is that placing difficulties in terms of the magistrate in both cases to navigate through, so that this one, the state has already alluded to the fact that they may even proceed without the 2 that are currently in Eswatini?
You remember that the core point is the fact that the accused persons have right to a fair trial, and amongst other rights is the fact that their trial should commence and be finalized speedily without unreasonable delay. So what may be of impact on this particular court is the fact that the Eswatini extradition is taking some time. And one of the things that were evident on the current sitting of the Eswatini Magistrate Court was the fact that the applicant, or rather the respondent in Eswatini, are demanding a full disclosure of statements and content of the docket in this court to be provided to the counsel, the defense counsel in Eswatini. And you understand that if anything can now become public in terms of the investigation, that of course will then jeopardize the further investigation in this particular case. I'm alive to the fact that it will not change, but I'm not so sure if the state at this stage is confident enough to have copies of the docket disclosed in another jurisdiction.
Are you happy so far with what has already been presented by the state? Last time around we were a bit skeptical about how the state has handled its matters, especially regarding the fact that they've already alluded to the fact that they will take about 4 to 5 months to complete their investigations.
Remember that when this matter broke into the public, it was as if the state had finalized its own investigations, and it was as if they are towards the end of being ready to proceed with this matter to trial. But we learned last appearance that they're actually not ready. They still want another 4 to 5 months to finalize the investigations, which of course will then say, why arrest to investigate? Why can't you investigate then arrest? So that are point of the things that Advocate Mlotshwa ventilated on when when we were here last time. So the worry was about the issue of time. We don't anticipate and we're not expecting this matter to run for another decade without having been finalized. We were hopeful and confident that the state has done its part to bring this matter for trial sooner than later.
And also, of course, the state's trying to prove the fact that some of the accused were not that honest, and also there was a non-transparency when it comes to that 800,000 rand allegedly paid by a famous or prominent Durban business person, Mfundo Caba, to one of the accused number 4, Gwabeni. There was no full disclosure with regards to his bank account.
And that is what the court last time was particular when the matter was before the court for argument. This magistrate was particular to the counsel for applicant number 4, Gwabeni, to say, don't you think, address me on the issue of transparency on the part of your client, to the effect that when he made his application, he did not disclose fully. He did disclose the bank statements, but the bank statements account for a period before the payment of 800,000 and after the payment of 800,000. But it did not, regardless and despite the fact that he bears the honors to, on balance of probabilities, to put the court into confidence that the state's case is weak and the fact that the interest of justice permit his release on bail. But his role was also to put the court into confidence, to say, if you say this was a business transaction, disclose and show the court how these things were, the money was distributed. But he intentionally decided to omit that part, and that may work against him when the court determines his eligibility to be admitted to bail.
Yeah, let's us now zoom into the accused number 3, A.D. Mieza, whom the state is saying that, the defense is saying that it's got nothing to do with this, even though he is alleged to have been the supply the firearms. But how will the state and also the courts ensure that under the doctrine of common law, this was also part of this alleged gang?
Remember, you can be, in terms of the doctrine of common purpose, you can be convicted of an offense where there is an intention displayed to say you acted with common cause, with common understanding to achieve common goal. But of course, in this particular matter, because we are not in the trial court, we are in a bail application. The court is going to consider what is before it. But of importance, you'd remember that part of the factors in terms of the Criminal Procedure Act in Section 60 is to show whether or not the accused person, if they are admitted to bail, are they not likely to commit a Schedule 1 offense. And given that he has pending cases which are more similar to this, and he's also the supplier of weapons, and this court was very particular to say, can the counsel address the court on issues of whether or not he should be termed to be a person who is associated with violent crimes? Can the court drown in an inclination today to say he is associated with the commission of violent crimes? And that may work against him, considering the fact that he is the supplier of weapons. Even on the other matter, which is called the Berea matter, he was the supplier of weapons, and possession of firearm and ammunition, it's a serious offense.
How will then prove his motive and also his intention there?
Remember that it's not necessarily in dealing with the motive and the intention at this stage, but this court is to satisfy itself that there is a case to answer. And if this court is satisfied today that he is part of the people who must answer this particular case, and the fact that the interest of justice does not permit his release on bail, then this court is obliged in terms of the law to keep him in custody until the matter is finalized. Thank you very much.
Okay, that's our legal analyst, advocate Abigail Ngobeni Ayanda.
Right, Vusi Khumalo, thanks very much indeed. Vusi's live to us there from the Durban Magistrate's Court. As soon as that bail judgment is delivered, of course, we'll be back there in court for you. So catch it live here on the SABC.